name is Busisiwe Kamolani Khadima, and I am an attorney and research coordinator at the Center for Applied Legal Studies based at WITS University. The Center for Applied Legal Studies does work in public interest litigation and human rights law, and really showing our commitment to growing the social justice sector, to building the next generation of public interest litigation lawyers. We started in collaboration with the Student Litigation Society to create this public interest law moot court competition. This is its second year in running, and really the competition every year gets bigger and gets better every single time.
Prosper Tumani here from the Student Litigation Society. Excited to have brought the students of law across the nation the exciting public interest law moot court competition, which now exists as the largest domestic moot court competition across Africa.
We are honored to have you with us today, and of course congratulations to the participants that made it. But before we get any further, I would like to call on my colleague Prosper to take on further introducing the teams and our day.
We have Emily Moshidi and Lit Van Derhems. Representing University of Fort Hare, we have Elai Mikioni, Zilumi Lembali, and Chuma. And then interestingly, we have two teams representing Rhodes University, Chimwemwe Piri and Seiji Amis. And also we have PIL 24, also from Rhodes, being represented by Taban Oshodi and Tabisi Mashanti.
The reason why I decided to pursue an LLB is because of my genuine and constant passion for the law.
The reason why I chose to study law is because firstly, I come from a community where people commit crimes and they tend to get away with those crimes and nothing is done about it. Secondly, many people's human rights are being violated on a daily basis, and there seems to be a problem with getting access to legal justice in my community, and I believe that having a law degree will equip me very well to help those people to get access to legal justice.
I am deeply interested in the legal system that forms the foundation of a democratic society.
And the reason why I chose to study law is because I've always been passionate about law, and also I was encouraged by my background, where I'm coming from, because they used to believe that none of us from my village would become a lawyer or become a doctor. So I just had to make sure that I show them that we can make it.
Justices, in the case of Mazbuko versus Sisulu.
The reason why I chose to enter the PL Moot competition is that the experience it provides us as students in terms of how to argue,
to enhance my litigation skills.
What interests me about the PIL Moot Court is that we get to travel because I'm from the Eastern Cape. So when we make it to semi-finals or finals, we get to go to Johannesburg and also get to challenge other students. That's the most important part, to challenge other students.
What's exciting about this competition is that I'll be having the opportunity to argue before a panel of judges, constitutional court judges, and the feeling of going to Joburg, and when I make it to finals, I'll be having the privilege or the opportunity to argue in a constitutional court. That is somehow a dream come true. Yeah, thank you.
Please rise for the Constitutional Court.
Thank you to TELS and SLS for putting together such an important competition. And also, I imagine on behalf of my fellow justices, thank you very much for extending the opportunity to us for being here today.
Congratulations once again, and thank you very much, and good luck for today.
Calling the matter of Nomsa Gidi versus Eddie Mukwena and others for hearing.
Participating in this moot has essentially given me the opportunity to find out whether public interest is my niche or not. And going through this process, it's helped me understand that I do have a deep, profound interest in public interest.
The case concerns the violation of our client Unomsa Giti's labor relation rights as well as her constitutional rights.
With the court's permission, I would like to direct the court to the case of Satchwell v. President of South Africa.
Because by them implementing this policy in the school, they're implementing it in its private capacity.
Counter consideration there, whereas here there's obviously a public health counter consideration. What do we make of that?
My overall experience has been so great. It's exciting to appear in the Concord. Before you are even a lawyer, I'm still a student, and I had the privilege to appear in the Concord. That's very exciting. So the experience is very great.
If you can just assist me, what did the school do outside of just the suspension?
In answering that question, I wish to draw the attention of the court to the directives of the Occupational Health and Safety Act. As the highest court of this land, lower courts will be bound by your decision.
I will take approximately 15 minutes of this Honourable Court's time, following which my co-counsel will take another 10 minutes of this Honourable Court's time, of which we request 5 minutes for rebuttal.
It is in the interest of justice for this court to grant an application for direct access in terms of 167(6) of the Constitution, read with Rule 18.
Exceptional circumstances was emphasized by the court in the 2021 judgment.
And in the case of Mazibuko versus Sisulu,
how do we proceed to decide if it is indeed an unjustifiable constitutional limitation?
I accept what you say. How is that relevant for a direct access application?
The highlight of today was definitely arguing in front of the judges and the manner in which the argument proceeded.
This court's jurisprudence in the case of Bruce versus Felicitex Johannesburg, whereby this court stated that it is ordinarily not in the interest of justice for this court, the Constitutional Court, to sit as a court of first and final instance.
Justices, I shall be dealing with the sufficient agency, and secondly, I'll be dealing with the issue of whether the matter has a grave bearing on the soundness of our constitutional democracy.
I'd like to make it clear before this court that the applicants made reference to the dismissal of the applicant, which I believe either they do not know the facts or they are misleading the bench.
The overall experience in this Moot is that the Moot has been intensive, but at the same time very constructive and exciting. I've met brilliant minds who have challenged me.
With regards to this particular problem that the applicant is facing.
Thank you so much for your question, Justice.
Well, since it's my second time participating in the Moot Court, honestly, I have improved a lot. I've improved on the drafting skills, on the oral submission skills, on the issue of being able to persuade the court.
It was really wonderful to watch the contestants come to court today and put what we've been talking about and practicing over time into practice. I was impressed with all of them. I wish they could all win.
The two teams that will be progressing to the final, we have PIL, here's drum roll please. PIL 139 and PIL 14.
Ladies and gentlemen, we are gathered here for our second annual grand finale. So for the first time in the competition's history, we have an all-female team literally in the final. And I think that's something worth clapping for. To the teams, best of luck to you all. Do enjoy today's session. Thank you.
We believe that, as the applicants, we believe that if we come to the Constitutional Court, we have the opportunity of getting an urgent relief sought in terms of the unconstitutionality of the respondent's conduct, in terms of the infringement on our clients.
Are you saying that the applicant only relies on Section 12(2)(c)?
Are you saying that the vaccinations as they stand today, they are equated to experiment or now straightforward medical treatment?
Suspended.
Sorry, if I could just stop you there.
Chief Justice, I will be addressing whether or not the policy implemented by the respondents passes constitutional muster.
But on what aspects of we've been talking about the Constitution all the time. Section 9, Section 12, where are we now?
Would you want to cite the government in such an application, and would you want to bring forward the government? And what's the difference between a suspension? What's the difference between a suspension of a person at a public school and a suspension of a person at a private school? Just address us on that issue.
Each teacher, vaccinating as opposed to regularly testing and the associated costs with that.
Not be limited by policy at all, as you say. So why do you then go into checking the proportionality of the limitation?
It is in the interest of justice and exceptional circumstances that we appear before this honorable court today to ensure that our client is awarded the best possible.
And the main point that we would like to put forth is that the policy implemented did not take into consideration the rights of the educators that it be limiting. And we would like to state that, yes, rights are not absolute. However, if rights are to be limited, less restrictive measures should be taken before the extreme measures that go against the inherent rights are taken.
Thank you. That's a good summary. Council Moshodi, please proceed.
As it pleases the court, Chief Justice and Justices of the court, my name is Emily Moshodi, and I appear on behalf of the respondent, my co-counsel Lita van der Eems. At the end of the day, the applicant must follow due process, and the correct courts must be approached. The CCMA, the bargaining councils, the Labour Court.
Would that be an issue of urgency or not? I think that's what the Chief Justice wants to know. Can you approach the Labour Court on urgency, and what would your argument be there?
They say because it's urgent. You say it's not urgent. How can you say it's not urgent?
What is it exactly that the employer was hoping to achieve?
If she doesn't get vaccinated, she will be fired.
How do you justify that there was no investigation as to find out what the true purpose and what the true reason as to why she's refusing the vaccination? Surely the employer has failed there.
In this regard, I would like to draw the court's attention to the case of Cook versus Ndaka.
And the applicant has also failed to justify why they refer to section 9, 10, 12, 15 of the Constitution.
Can you liken the facts of those cases to this matter? I mean, high risk in what sense?
High risk in the sense that the employee engaged with a number of people and interacted with a number of people on a daily basis.
Section 24.
Council, can I interject?
Give us a strong bottom line, a strong parting shot that we will not get out of our minds before you sit down.
The applicant's suspension was substantially and procedurally fair in terms of the Labour Relations Act.
Congratulations to all of the teams. I think they deserve another round of applause.
Then the court adjourns. Thank you very much.